Colin might hit the button. Just let us know it's on. All good. Councillors, in the absence of Councillor Frank Wilkie, who's the chair of the meeting, I'll declare the meeting open. As you're probably aware, Councillor Wilkie and Councillor Wellington are both at the LGAQ annual conference, working their way through a stack of motions, having a look at the broader local government issues, but both will be back this Thursday night for the council meeting. So, in the absence of Councillor Wilkie, I'll call upon someone to nominate a chairperson for the meeting.
I'll nominate George Rusevich.
Moved by Councillor Jackson.
Second.
Seconded by Councillor Pardon. Any other nominations? Couldn't think so. I'll put the motion. All those in favour? Against? Carried. I'm going to come around and assume that it's the chairperson. I'll grab you.
That's right, I'll grab that. Such a call getting voted in army style.
Press gang.
Well, good morning everyone and welcome. Before we begin, I'd like to pay respects to the traditional owners of the land upon which we meet, the Gubbi Gubbi or Kabi Kabi people, and pay respects to their elders past, present and emerging. Where do we start?
The beginning.
Well, we've got apologies.
Yeah, apologies from Councillor Wellington and Councillor Wilkie. Both will be back for Thursday night's council meeting.
We have no presentations or anything?
No presentations and no deputations. The first item is the...
Straight on to the first item, which has been referred from the Planning Environment Committee. The proposed local law amendments, advertising devices, post-public consultation, proposed changes.
So I'm going to move the staff recommendation.
Do I have a seconder? No one seconding that motion, Mr. CEO, so
that motion would lapse.
Would lapse?
Yep.
Do I have an alternate motion?
Mr. Chairman, I'll move an alternate motion. The motion as printed with an amendment to para 4, and I'll read it. If you want me to, I'll just read out the amendment to the staff's recommendation there in para 4, and it. That right? You're right, Mr. Chair. Should I read that out?
Yes, you should.
Yeah.
I'm just waiting for a response. I'm happy to read it out.
Everybody have that. I think that was circulated anyway to all councillors.
Yeah, it was circulated.
It's for the purpose of the people who are watching.
Yeah.
If you'd like to read it out, absolutely.
Yeah, thank you. I was just waiting for the chair's response. And it says, allow one A-frame sandwich board as self-accessible per tenancy, placed on the property to which it refers, or where this is not practically possible, immediately adjacent to the property.
I'll second that.
Seconded Councillor Glasgow. I may ask a question of staff. If
point of order. You can't ask a question after a motion's been seconded and used anymore.
Once the motion has been seconded.
Thank you for correcting me there, Councillor Stockwell.
Councillor Pardon should be speaking to it.
Okay,
yeah.
Councillor Pardon.
Yes, thank you, Mr. Chairman. Yeah, look, I've been consistent on this matter with regards to small business A-frames, their advertising devices. I think sometimes governments, there's some overreach at times, and I think this is one of those times. I think if we look at the big picture, past councils, this council, and the old planning scheme, which was regulated, signage under the old planning scheme, and that we're changing that to a new local law. So under the old scheme, people were allowed to have their A-frames, and I think that was fine. I think, and the amendment here, if we restrict the people to their own property, as we know, many of the businesses are built to the property line, so it's not possible to put your A-frame within that property, so naturally you're on public property with your A-frame. Over the years I've not seen or heard great problems at all with A-frames. I think when we regulate and have a look, it's a sensible thing to educate the shoppies, business people, so that they don't put the A-frame in some place where someone might trip over it or have an accident with regard to it. And if I go back through my history to 1997, there's not been a problem with A-frames with regards to legal matters, etc. So I don't have a problem with them. As I said, I've been consistent on this point, and I think the main thing we talked about signage in the old council was the pylons. There's a big debate over McDonald's, big signage that wasn't in keeping with the Noosa values, and I support that. But I just think the little fish of the day sign or cup of coffee sign that goes with small business, I just think to take that away is an overreach. So, thank you.
Thank you, Councillor. Other councillors want to speak to the amendment?
I would like to move
Councillor,
an amendment.
an amendment.
Yeah.
Councillor Jackson.
Once again, point of order, you can't amend an amendment.
That's not an amendment, that was a motion.
Ah, sorry, yes, thank you, I apologise.
Yeah.
I forgot I was
I'd like
unsuccessful.
to listen.
You were unsuccessful. That's right. You were unsuccessful. That was the motion. This is an amendment to the motion. So, Councillor Jackson, and the amendment
This
to
is
be.
about real estate. Shall I read it before? Yes. This is an amendment to the recommendation that only one real estate direction sign be allowed in front of the house for sale, property for sale, and instead that it go back to how our local law was previous to the last change, which allows 4 real estate signs, directional signs. And
My suggestion
Yes.
would be read it out.
read the whole thing?
Yeah,
Okay.
I think you need to.
That amendment, that item A5 be amended to read as follows. Allow 4 real estate directional signs per auction, open for inspection, with the following criteria. 1. Signs may only be placed on the day of the auction open for inspection and removed immediately after the auction open for inspection. And 2. A sign must not exceed 750 millimeters times 400 millimeters or 0.3 meters squared in area per side. And 3. Only 4 directional signs per event are permitted, including the auction and open for inspection signs erected at the property. And 4. Signs may not be placed on the roundabouts, center traffic islands, median strips, or any state-controlled road. And 5. Only 1 sign may be placed at each intersection. And 6. Signs shall not be illuminated or animated.
You need to call for a seconder.
I'm calling for a seconder. About to call for a seconder. Do we have a seconder? I'll second
I'll
that.
second for debate.
You can't. So just as we go through, I suspect this won't be the last amendment we get.
We'll
Just
have,
a
we'll have several.
quick bit of advice. So with Councillor Pardon and Councillor Glasgow moving the original
Original
motion,
motion,
either
okay.
Councillor Pardon or Councillor Glasgow will be able to second any or move any amendments.
Yeah. So hence I'll second.
Okay.
I'll second that
Thank
to allow
you.
it to be discussed.
Good. I'm moving this amendment because we have received, I believe, a petition with 98 signatories saying that they would prefer to see real estate agencies to be able to put directional signage on the streets. Can I just ask a quick question before I continue? The questions around the current existing rules around directional signage allows 6 real estate signs.
That's correct.
When did that change and what was it before?
So under the former local law, which was number 16, which predates the current local law, it was 4. And then under the current local law, it became 6.
And how long ago was it changed to 6? Do you know? Oh, it doesn't. It's not a major.
I don't know the exact. I'll have to
It doesn't
find out
matter,
the
it's not-
exact date of that.
it doesn't bother
but
me,
The
yeah.
99.
99.
Was local law.
Changed to 6.
No, that was the date of the number 16 local law. I'd have to find out the date when
That's
it changed
fine.
to the current
That's
local
fine.
law.
Okay. So look, I'll just speak further. My understanding is that we've had the 98 signatories in favor of allowing directional signage by real estate agents. I have been aware that we have been allowing 6, and I understand that previous to that, I think it's only about a year or 2 ago, I don't know. it changed from 4 to 6, and I think the aim in this review of signage is to reduce the clutter in general around Noosa. I do feel I know that we've received a letter from one of the very large real estate and very successful real estate agencies saying they don't see the point of having signage because people can find things through a GPS on their car. But I think this actually could discriminate against the small agencies, the small businesses that also are agents, because they don't get the big jobs. They get the little places all around the hinterland. And I've had feedback from agents that in the hinterland, where it's a bit hard to find things, and often also in new estates, which haven't been, Google Maps hasn't caught up with all the roads on the new estates, and hasn't caught up with, and neither have how cars, their GPS systems, unless you spend a lot of money, become out of date fairly quickly. So there are actually quite a lot of houses located in places where these GPS things don't work. And my concern is that this, first of all, disadvantages buyers, but it also disadvantages small businesses. Also, I would argue, if adhered to correctly under the law, which is that they be put up just before inspection and removed immediately after, you could argue that it's not really a pure advertising sign, it's helping people find a house. It's directional, that's what it is. In contrast, the recommendation in the draft local law currently suggests that instead of allowing the directional signages on the streets, that the directional signage be placed, only one be allowed, and that it be placed directly in front of the property for sale. Now, the property for sale assumedly has a for sale sign, so to put a directional signage right in front of it isn't actually helping anyone find the house. So I feel that that's a totally inadequate solution, and therefore I'm suggesting going back to the previous local law, which had 4. I think 6 may be, sure, there may be lots of reasons to have 12, but I mean, let's go 4 back to the one that was less clutter, and I said, that's what I recommend.
I'll ask a question if I may.
With regard to all the other parameters there, apart from the 4 signs, are they as per the current local laws?
That's correct.
Thank you, just wanted to clarify that. Any other councillor want to speak to the amendment?
Oh yes, I won't be supporting it. There's a good reason staff have recommended a change to this. This is because it's become a plague on our roads. It's degrading the Noosa brand, because every Saturday and Sunday and most other days you've got people just littering the intersections throughout it. It's one where the industry hasn't been self-managing, and as a result, in my opinion, the aesthetics and the non-commercial feel of our roads and entranceways into towns and villages has been impacted. So I don't believe that the amendment as proposed has the interests of the Noosa economy at heart, and therefore I won't be supporting it.
Councillor Pardon.
Mr. Chairman. Yeah, take on board all the councillors' comments here. Never easy to make these decisions. I guess, given that the amendment before us talks about one day only, I think that's good, 24 hours. The other thing is, in amongst this, we have because it's a local law, and we'll be putting on in the future officers, at least one, and maybe more in the future, given the regulation we're bringing with other local laws as well. On the face of it, I don't have a particular problem with that 24-hour for signs. That Councillor Stockwell's quite correct when he says, well, we've had a lot of issues with signs and clutter, and that's what we're trying to address. But I think if we've got the people in place to actually regulate, I mean, we've been short-handed with regards to regulation, I believe. Staff haven't had the resources to actually regulate lots of things. I know we had a signage audit, but there's a but ongoing here, and we have to have regulations and people to actually enforce these regulations. So, on the face of it, I'll support the amendment.
Question, what's the actual time frame now for the signs out there with the day?
So as per the recommendation, it has to be moved immediately after the auction open for inspection.
But they're not being, are they? They're hanging around
That's
for
the one of the issues.
quite a bit longer.
They're staying
And
That's it.
but
over the weekend.
as Councillor Pardon saying, with the local law officer coming in there with targeting them all now to get rid of them straight away.
Well, a compliance officer would have to probably operate over the weekend because this is mainly when the issue is to regulate it or check it, count the signs, and I guess ensure that real estate agents are removing them after the.
Do you know if it'll be 2 strikes out, 3 strikes out, straight up infringement, how you'll enforce it if they're busted?
Right, so that Kim?
Yeah. We don't have a 2 or 3 strikes you're out in this local law. However, you know, our practice would be to advise verbally if we can, then in writing, before we move directly to infringements. Obviously, if there was multiple occurrences, it is likely that we would move to infringements.
And as such, that would result in a fine?
Yes.
So there is an element there of the possibility of providing education as well to real estate agents.
Absolutely, that would be the first.
In the first instance.
Absolutely, always. Yeah.
Could we be even more proactive if this was implemented and on a periodic basis remind all real estate agencies of their obligations under the local law, particularly if this starts to become an issue and issue a means of educating the
Yes.
agents?
Yes.
Do we do that now?
Yes.
Yes.
And do we have a compliance officer available on the weekends when real estate agents typically have their? We don't. Local laws officers aren't available on the weekend to.
Local laws officers are available on the weekend, and we do have rotation and rosters. At the moment, we're not doing signage compliance on the weekend.
But if a complaint was raised over the weekend, could an officer be available to attend and deal with the issue with the real estate agent?
I think with our current level of resourcing we put into weekend regulation, the local laws officers are really focused on traffic issues, dog attacks, those sorts of things. They're not actually dealing with signage, so we need to put in additional resources if you want to have a look at weekend enforcement.
The alternative to that could be Monday morning a complaint's received and someone then visits the real estate agency and discusses the issue with them and educates them as to the signage regulation.
Only if you'd have the evidence there at that time that the sign is still out on a Monday.
Okay. Or it had been left out over the weekend or whatever. Okay.
Just a question.
Question?
Through you, Mr. Chair, to start. How many points, when you say the fine, how many points is they up for? And that points totals X amount of dollars.
Just have to check that, Councillor Pardon, because it does vary depending on.
Yeah.
It's a good question.
Is it 10?
No, I think it was 20
I
for
think it's
temporary.
20, which is 2 points, which is about $265
$265
approximately.
Okay.
Temporary is 20 and permanent infringements 50.
All right. So any other councillor wish to speak to it?
Yeah, I might just ask a question.
You can ask another question.
As there was a question about enforcement, I'm encouraging people to use something called
Send solve.
Send Solve, where you can use your smartphone, take a photo, it automatically recognises where the thing is and then sends it to council. Would digital photos like that sent to council be sufficient evidence of real estate agency signs being left somewhere longer than Saturday or Wednesday?
I can answer that.
Yeah.
So if we issued a fine and someone wanted to contest it in open court, we have to call the person who took the photo and get them to demonstrate what time they took the photo and where they were and so on. So technically that would be the case. Whether that person wants to get involved would be another question.
My understanding of SnapSend Solve is that it is GPS located and time stamped as to.
Correct, but in terms of evidence before a court, you'd have to call a witness to put that forward.
If it went that far.
Yeah, got that far. If someone paid a fine, had a ticket or whatever and paid the fine, then it's a bit of an academic question. But if they
If they want to
contested it,
contest the fine.
correct, yeah.
Thank you.
Just a
Councillor Basco,
question.
you want to speak to the
No, just a
amendment?
quick question. Only one sign be placed at each intersection. That's how many intersections could there be in an entry though? It could be 4 intersections, right? 4 corners, is it? Or is it just one sign on each corner?
That's to the
Is it to me?
amendment.
Yeah, sorry.
Oh, sorry. So if you have an intersection, that means 2 roads cross over.
Yeah.
It means you can only have one sign there.
Oh, okay. Yeah,
Yeah.
I get it now.
If there's no one else, I'll speak to the amendment. I'll support the amendment. Quite often we're told that these are issues, but I think with the way to deal with an issue is not to denigrate the industry or to turn around and take away the privilege of signage, but it's to educate and to resource accordingly to ensure that where necessary enforcement can be undertaken. I don't find this personally. I don't find this an offence. Seeing some real estate signs, I find it quite a useful tool. I find it as a directional tool, and I've often utilised the opportunity of seeing a sign of open for inspection to partake of an open for inspection just to see a particular property, maybe one that I have shown an interest in the past. So I think a lot of people do that. I think a lot of people, particularly around a neighbourhood, might turn around and take the opportunity to go and find out that, oh, look, I didn't know that house was open for inspection. I think the current wording in the local law of one sign out the front of a property where, as Councillor Jackson alluded to, is a little strange because there is, as you Councillor Jackson stated, already a sign out the front of the property stating the property's for sale, and that could have, open for inspection sticker across the front of it. So I think the idea of a sign out the front of the property is quite a nonsense. I think 2 or 3 or even 4 signs on the roadways leading up for a few hours on a Saturday morning before a sale and taken down immediately afterwards is not going to offend anybody. And in 6 years of being on council, I haven't had one email or one phone call telling me that real estate agents' signs are an issue, but I have had one comment from one real estate agent that gets offended when agents don't do the right thing because it sets a bad light on their industry as a whole. So, and I think we have received some comment from one of the larger agencies in that regard. Again, it sets the industry in a bad light. So, as the industry, I think they should be aware of the problems that they do set, and with a bit of regulation and a compliance officer, I think we can manage this. So I'm supportive of the amendment. There being no further discussion, you want to close, Councillor Jackson?
Sure, I will close. I'm encouraging returning to our existing rule and leaving it as it is, except reducing it to 4 real estate agent signs, which was the case a while back. That way we're trying to offer a compromise towards reducing clutter. I will respond to Councillor Stockwell's suggestion that removing real estate agent signs, or that having real estate agent signs is not in the interests of the local economy. I would suggest removing them is not in the interests of the local economy. I think that we are, aside from being a tourism place, we're also very much a real estate location, and both our residents, our visitors, and of course our small businesses are dependent on these real estate agent signs to help this operate properly. So I would suggest we want to support our small businesses, and that is one of the things, an example where we can do that. Thanks.
Very good. Okay, there being no further debate, I'll put it to the vote. Those in favour?
You need to call the names.
Oh.
I will. Councillor Pardon, Jackson, Glasgow and Jerusalem. Those against? Councillor Stockwell. Declare the amendment carried. So the amendment becomes part of the motion.
So I have a question of staff, please, Mr. Chairman. Both the amendment and the original motion propose signs on public land. I know staff have previously brought up the issue of liability and insurance cover. Does allowing continued signage, does that expose council to any risks associated with potential damage for injury caused by signs on public land?
Brett, you might want to comment here also. Yes, liability of these signs on public land does create some exposure to council. We have had some complaints of particularly temporary signage blowing over in the wind, being in the middle of pedestrian pathways, being obstructing access ways and movement, which has been part of the reason we've been looking at signage and appropriate placement and considering how we regulate them going forward. So yes, there is potential when signage is placed on public land.
I'll probably just add that, I'll confirm that. And on the other side of the equation is that I can't recall any claim where we've had to pay out over recent years, but that possibility is there.
Answered my question.
So the question I have, would the sign placer having public liability insurance cover any element of that?
No, we are the public authority in relation to the public land, for want of a better phrase. So one of the attractive things about council is we're always here and we've got deep pockets. So if anyone's going to sue someone in relation to what happens on a footpath, it's going to be the council. We might try and join the owner in that action, but it's always the council that is a very attractive defendant in any public liability claim.
So by permitting signage on public land, public liability insurance has no element of what's the word I'm trying to find here? Responsibility with regard to any damages that may be caused to a person or property.
Are you talking about our public liability?
No, I'm talking about the person that's placing the
Sure.
sign, the business that's placing the sign.
Yeah, they may be a joint defendant, but as the owner of the land upon which an event or an accident occurs, we also have liability.
So if there was a permitting system whereby such liability cover was requested, such like if you hire a public hall these days, you have to show a $20 million public liability insurance. If you have actually permitted it subject to that, does that change the legal situation at all?
It would certainly make the owner of that sign or whatever the event jointly liable, but as the owner of the land, we have liability as well. Potential liability, I should say.
With regard to other property on public land, such as public place dining, we have a permit system currently. How does that? How does a sign on public land differ from dining equipment such as tables and chairs on public land?
Joe, I'd have to take that one on notice. I haven't thought that element, whether there's different in terms of how that works. So I'd take that question on notice.
And I've got a question, now that we've gone through that amendment, I've got a question relating back to Councillor Pardon's initial change to the staff proposal. With that that change there, does that take into consideration elements such as sign placement, sign safety and stability? Or would we have to specifically add those criteria relating to those elements with regard to A-frame signs?
We would include the current criteria associated with that recommendation. So the current criteria relating to the placement and size and everything in the local law, we would add to that recommendation. However, I guess you could.
Well, I'm suggesting, do I need to make that that amendment now to incorporate it now, or is that, or would that automatically be covered if we didn't add it into the motion as it stands?
I would automatically include it.
Yeah. Can you maybe just explain what you're saying?
Well, I'm just saying, you know, does the 4 need to add the provisions of with criteria relating to sign placement, sign safety and stability and public liability insurance?
Yeah.
I would think you would include that.
Or you could include the current requirements, the current criteria verbatim.
Can you just read out the current requirements?
So where is that one up to? Possible. The sign may only be used when the business is open, and a maximum of 1 sign per tenancy is permitted. and the sign must be placed on the property to which it refers, or where this is not practically possible, immediately adjacent to the property, and the maximum size permitted is 900mm by 600mm, or 0.54 metres squared on each side of the sign. And we would not be including this next one, which is 1 teardrop sign may be displayed instead of using an A-frame.
Well,
So we would exclude 5, what I've just read out.
Sorry, would it exclude 5?
So exclude the last criteria that I just read out,
Oh,
which
the
is
one
the
with
current
regard
one,
to
which is
teardrop
regard to
signs.
teardrops.
Joe, can I suggest that it would be easier if you just put, if you, that struck out, subject to the amender, struck out only on private land, and just include with criteria relating to sign placement, size, safety and stability.
That's what I'm getting to. It.
Yes.
We've got an amendment
Yes.
to do that though.
Yes.
Yeah.
So I'll move an amendment to include those criteria.
So we need to get that wording right. Council, I'll just make an observation as well. We've got, as you know, a couple of councillors away. This is probably one of the trickiest issues I think the council's dealt with for a while. I made a statement the other day, it was half in jest, but I think it's half true as well. I think amongst the 7 councillors, there's probably 8 different opinions around this issue. And there's not much doubt in my mind it'll have further discussion at the council meeting on Thursday night. So my advice would be whether we'd be a little bit careful about trying to make amendments on the run, and we look at how we then get wording that will be debated on Thursday night.
Yeah,
All right. Can I? Well, rather than make the amendment here, I'll ask staff to consider what wording may need to be added to that, and bring it forward for
So
Thursday.
just before that, Joe, you're comfortable
I
that
am.
would work?
Yep.
Okay.
with
Well,
what Kylie's just done,
Yeah.
that revised.
We changed it, or is it the same? No.
So you happy with that wording?
Yep.
okay.
All right. In that case, I will move that amendment.
Okay.
Yeah.
Ask for a second.
Can I have a seconder, please?
Yeah, I'll second
You can't. Jeff, you'll be out for all the second
Oh,
because
you
you read the
can't
second
second.
the original
Oh, okay.
motion.
So it's only Councillor.
We can't.
I've seconded it.
Thank you, Councillor Jackson. Speak to
So,
it.
can I suggest you read it out?
Yeah. So that item A6 be amended to read: allow 1 A-frame sandwich board as self-accessible per tenancy be placed on the property to which it refers, or where this is not practically possible, immediately adjacent to the property, with criteria relating to sign placement, size, safety and stability.
You speak to that.
That clear and understood? I think that, I supported the original motion by Councillor Pardon, but I think this just clarifies some of the criteria around which A-frame signs should be placed, and is in keeping with the current laws regarding to A-frame signs. I don't think anything more needs to be said.
I might just speak to that as well.
Councillor Jackson?
I support this amendment, and I'm always in favour of making everything very clear and documented, so I think that's a very helpful addition.
Anybody else wish to speak?
Yeah, yeah.
Councillor Pardon?
I support the amendment naturally. I guess I thought that would automatically be in there because it wasn't excluded. So
Thank you. That's why I sought
expect
clarity.
yeah,
Thank
no,
you.
and good work, Mr. Chairman, to tease that out.
Anybody else wish to speak to the amendment? I don't think I need to close, so we'll take the vote on that. All those in favour? That's Councillors Pardon, Jackson, Glasgow and Jurusvik, and against? Councillor Stockwell. The motion is carried, or the amendment is carried, it becomes part of the motion.
Mr. Chair, I have another amendment.
Councillor Jackson.
Which one have we got here? Yes, I'd like to make this amendment about the definition of tenancy, but perhaps before I move that, I'll ask about where the current recommendation is that the tenancy not include separate sublet businesses. Where are examples? What are examples of locations or tenancies where this would apply?
So probably the main obvious example is along the river, where you've got lease areas, which is regarded as the tenancy. However, in those tenancies, there might be 5 businesses operating. So it might be the coffee shop, the boat hire, a tourism operator, and another business. So each of those sublet businesses, it's one tenancy. Putting out the example is the A-frame sign per business. So the intention of this was to clarify that the signage allowance, which is the 10 square metres and 4 square metres of individual signs, applied to the principal holder of the lease, the tenant. And so that regardless of the number of sublet businesses operating there, the 10 square metres only applied once.
Are there any other types of properties where this would apply, or is it in particular relating to the jetties?
You have examples where there's been an issue?
There'd be examples in the industrial area, would there not, of primary and secondary?
Yeah, we've just got one property, but there's a lot of tenancies within that one property.
One property not separately titled.
That's correct.
Yeah.
So it is the intention when the legal drafting is done that where there is one premises, and probably the industrial area is an example where it hasn't been separately subdivided, but they are obviously tenanted leased areas, that application would apply in that instance.
In the same way?
Yes, in the same way as if they were a tenant with their own lot.
Right. So they wouldn't be allowed to have their own.
No, they would be allowed.
Oh, they
so,
would.
So an example where you've got one lot hasn't been subdivided, but it has one building on there with separate tenancies within it.
Yes.
Each of those tenancies, the obvious tenancies, would still get the 10 square metres allowance.
Are they called sub-tenancies or are they tenancies?
No. So the way that we will draft the, it'll be a legal drafting exercise, will ensure that each tenant is related to a lease area, so they have a lease area or a lot. So it's quite clear. That lease area or lot area may have 3 businesses operating in there, but the application of the signage only applies once.
So how will you clarify the difference between a primary lease and a sublease, because both are leases in legal text?
Yeah, so I guess that's something that we're working with the lawyers on to clarify the intent there, to make sure that we get it right. But the intent is that if there are, that example down at the river where, you know, if there are 5 small businesses operating there, but there is only one lease area there, that they don't get 5 times the 10 square metre allowance. It only applies once to the lease area.
I thought we were talking about A-frames.
No.
Oh no, that was an
Signage
example of
overall.
where they're taking up the rights for each business in that instance.
Oh, I see.
So that
was just an
definition
example.
applies to all the signage, not just the A-frame.
Can I ask Jamie or yourself, of how many jetties, public or whatever they are, commercial jetties on the river are there, and how many of those would have 5 subtenancies?
I think there's approximately 7 jetties down there, and the majority would have like coffee shops and subtenancies.
Yeah, but I'm hearing the word 5, and I'm wondering whether that's the case for most
Up
of
to.
them.
Sorry, I
Yeah.
probably should have said
I mean, I do walk there every morning.
Yeah.
I'm not under the impression I'm seeing that many A-frames, let alone that each of those jetties has that many subtenancies. They seem to have, some of them just have 1 or 2.
In the council workshop, I did provide an example of one of the jetties that had, I think 4 or 5 A-frames each for whatever they were operating in that tenancy. I wouldn't suggest it's all of them, but we're trying to ensure that there's only 1 per lease area.
Just to assist, Michael, you probably couldn't answer that off the top of your head about, you know, what makes up each of those seven at the moment, but you can probably take it on notice and have that information for Thursday night. Councillor Jackson, if that's okay.
Well, I'd like to have another look at this amendment.
Can I just clarify an element of that of your wording there? Are you trying to rate that to signage overall or just to A-frames?
Well, I had thought it was, I was thinking of A-frames because I wasn't thinking of the law. I didn't envision 4 square meter size.
You're amending the definition that will apply to the whole thing.
I wasn't.
Yeah.
I'm okay. I might have it reworded, if I could request a rewording to specify this is about A-frames, and then I'll remove this at the
So my suggestion is from today that Councillor Jackson notes that she's withdrawing the proposed amendment and request staff to work on the wording to bring forward for Thursday night.
Yeah.
Okay. So that the tenancy just applies to the A-frames in terms of our definition.
Thank you. That's fine.
And that there's 1 per Yeah, anyway, we can clarify that.
So we would probably amend the criteria around A-frames in that regard.
Okay.
Yeah,
As opposed to sub.
as opposed to the definition of tenancy.
Yeah, I'm happy
There's
to work with
different
you
ways
on
of
that.
doing it.
Yeah.
Yeah, okay. Alright.
Question more generally, would it be appropriate, because we are going to have quite a few amendments, that we request staff bring forward a report? So on this one, I'm aware that we do have complaints. I'm aware that we do have a range of different issues that are I would prefer to make an informed decision on each change that is proposed. Is that needed to be a motion, or is this something we can request from this meeting that a subsequent report?
My suggestion is you get to the end of this process we're working through now and then make that determination.
Okay.
Thank you, Mr. CEO. Councillor Jackson.
I do have one more amendment to offer. And thank you for helping me draft this amendment. When in May, we originally were presented with recommendations from the staff about changes to the local law and of course the integration of the Noosa plan with local law details. One of the recommendations was the one I'm putting up here, and I'll just read it over, that that item A13 be added to read as follows: increase the maximum individual sign allowance in the Cooroy and Noosaville industrial zone to 6 square meters on a sliding scale of 0.75 square meters per linear meter of street facing building, excluding Umandi Noosa Road and Walter Hay Drive as the gateways to Noosa, in recognition of larger buildings and industrial nature of the area.
Second it.
Councillor Stockwell, seconded. I think I need a moment.
See, I know it fell out of his chair.
Well, that was unexpected.
Councillor Jackson, would you like to speak
I would
to
like
the
to
amendment?
speak to the motion, yes. Well, perhaps I'll ask staff if you could comment on the rationale why you brought this recommendation forward in May.
So at the time, I guess we were looking at the scale and size of the buildings and the land use nature of the area, and thought it appropriate that, again, still on a sliding scale, that these larger buildings could accommodate an appropriate sign type up to 6 square metres. And so we thought it was appropriate, but not along the gateways to Noosa, being Noosa Umandi Road and Walter Hay Drive.
And while it's not written in the wording of the motion, as I understand it, Anita, this would not change the maximum signage area for the property, which I believe is 10 square meters.
Yes.
So even though they could have a bigger sign, one bigger sign, it doesn't mean they would have a lot more signs. Is that right?
That's correct. So currently, or the draft local law, as is the current requirement, is 4 square metres for an individual sign. This was proposing the individual sign be increased to 6 square metres, but still the upper total of all signs on the building be 10 square metres.
Right.
So there would be no change to the overall maximum allowable signage on the site, just the size of the sign.
And I may also ask, I believe that it was perhaps last month or the month before, council dealt with another matter, which was a sign in Noosaville industrial area, where a report was written by a consultancy for council, in fact?
For council.
And
sorry, Councillor Ingrid, that the applicant did a visual analysis.
Yes.
And submitted that,
It was
and we had it reviewed.
You had and there was a report presented.
That's right.
And as I recall, and I haven't got it in front of me, but as I recall, there was a point made that by allowing such a larger sign, it would actually potentially reduce clutter because there'd be less signs likely on that property. So it would just be a more visible sign, and that was actually a reasonable idea.
That report, as you might recall, that we were in appeal over that sign because it exceeded the maximum sign size, and through a process of contextual analysis, character analysis, visual analysis, a number of issues were considered, and officers proposed to council that we agree to that sign because of its context and size, and also an agreement by the landowner that they would reduce other signs on the site.
And to settle that appeal.
And to settle the appeal.
But I was also asking about the report that was presented to councillors, that's what I was asking about, the rationale provided in that report, and that I understand you are confirming.
Yes, there was a number of considerations, and reducing signage on the site proposed by the applicant was one of those considerations, to allow the one bigger sign and reduce their other signage.
And I do recall that sign was bigger than 6 square meters.
That's
Is that
correct.
Yes. So that was unusual. Yes. Okay, well, I'll just, I'll just speak to the motion. I feel that, I guess I'm suggesting that in an industrial area, and that's mostly Noosaville and Cooroy, that we have industrial zones, that we have quite a different type of building. They're quite often larger lots with largish warehouse-style buildings. Sometimes they're set back from the road and not so easily visible. So, and other times they are closer, but nevertheless, it is clearly an industrial area. People don't necessarily drive up and down those streets except to access industrial things. And I think it is a perfectly reasonable thing to allow just slightly larger signage, and it's got a sliding scale, so that means that if it's a very narrow property, the sign couldn't be bigger. It's a matter of customizing or suiting the situation. And I think that proposal that came to us previously, and I'm now putting again, is a very reasonable approach in a particular context, which is industrial.
Thank you. Any further, Councillor, Mr. Speaker? Councillor Pardon?
Oh, well, Mr. Councillor. Mr. Chairman, Mr. Councillor. Well, you are.
Yes, Mr. Councillor.
Mr. Chairman. I guess looking back, I sort of suggested that to different precinct, if you like, the industrial estate, and talking about different precincts treating this differently, because it is an industrial estate. I'd say going forward in the future, there'll be amendments looking at other future councils. We'll look at amendments to these local laws, what fits, what works, what doesn't. Nothing's set in stone forever, and we're doing the best we can here, or what we think to make Noosa what it is, or visual clutter, etc. Just a question here. I'm not sure. It's like laws we set, and councils can set many laws, and that's fine until they're tested in a court of law, and sometimes those laws are challenged, etc. So the question, Yamundi Noosa Road and Waldhay Drive, and I support that absolutely. I'm just wondering through staff with regards to the differential, I guess, in the industrial estate when they're drafting, the difficulties of this. Is that seem difficult?
From a drafting perspective, we could just map the area, and that would be very clear what properties were in and out.
Yeah, okay.
And that would probably be the easiest, clearest way.
I don't have any concerns that you could draft up something along these lines that would stand.
Okay, it was just a question, a challenge, if you like, from other. Okay, yeah, I'll support the amendment.
Councillor Stockwell.
Yeah.
Hang on.
You shouldn't be surprised, because we've talked about this as a concept for a couple of years now, and I've always said I think it's something that's reasonable to consider. It is contextual. It is about the maximum sign face area is about retaining character. Within industrial estates, we have a bulk and scale of building where an extra 2 square metres is unlikely to have any influence on character whatsoever. I think it's a reasonable approach. It's not increasing the overall site. Therefore, I support it.
Councillor Jackson?
Yeah.
Glasgow, sorry.
Yeah, it's all been said. This is precinct approach was a great idea, and I'm supporting it as well.
Thank you. Question of staff. My understanding from the feedback we've got with regard to signage laws that there was some community support or quite significant community support for a differentiation between industrial area signage and commercial signage. Is that correct?
That's correct, and the joint submission from the business associations also requested a need to look at a more precinct location-based approach in the future.
On that basis, I'll be supporting the amendment. I think the amendment has merit. I think I've argued long about size and scale, and I think when we've talked about shopping centres in the past, I've referred to size and scale. I think there is an element where the size of as Councillor Stockwell alluded to, the size of a building does give credence to looking at the size of the signs there. One of the most interesting things that come before us in recent times is the premises in the industrial area that brought forward a visual analysis, and it did shed signage in a different light with regard to, distance back from the road and the like. I mean, you may, a 4 metre sign right up close compared to a 4 metre sign that's set back 20 metres. I mean, there's a significant difference there, and I think there's merit in going back and reviewing this further in the future. But for the moment, I'll be supporting the amendment. So I'll put Councillor Jackson. Do you wish to close?
No, I think I'm fine.
Okay. Well, I'll put the matter for a vote. All those for? Carried unanimously. Are there any further amendments from any other councillors? All right, I'll start on mine then. I had a similar sort of a vision with regard to the tenancy definition. So I wanted to make the following amendment. I believe the girls have got it there.
Hang on, which one was it?
It was 6, and the ones that you had typed out for me.
This one?
That one. I did circulate them. I'm just not sure that all councillors had a chance to do it. So if you'd like, I'll read out the change. That item A6 be amended to read as follows: amend the definition of tenancy to clarify signage allowances of 10 square metres applies to the principal tenancy holder, inclusive of any sublet business signage. And I'll ask a question of the staff before that's seconded, if I may. With regard to what Councillor Jackson alluded to there, I mean, there's the intent here was to limit signage for, being able to define a sublease and a sublet as opposed to the principal lessee. Given that we're talking about getting some clarification, some legal clarification, that may, I'm happy to leave this if other councillors want until we've got that legal advice. But the idea here was to prevent one business from then subletting a space, and each business then within that sublease area having the capability of having a 4 square metre sign out front and 10 square metres overall, which in the case of a lease along the river, for example, of having a 5 sublet or one lease and 4 subleases of 5 lessees in one occupancy to turn around and have the potential to have 50 square metres of signage out front. So that's the intent of what I was trying to draw here.
I think that's consistent with our intent.
That's right.
On that, regardless of how many businesses were operating. And I think this clarifies it further. The maximum is still 10 square metres.
And that's irrelevant of A-frame signage. That
doesn't include A-frame signs. Actually, aren't calculated in the 10 square metres. They're kind of like a bonus allowance anyway.
Okay.
Yeah.
All right. Well, I'll make
that's
that
a separate issue.
Before it's seconded, I wanted to just clarify my understanding of them. By doing this, it would have the unintended consequence of not including that clarification for A-frame signs, because it refers only specifically to the 10 square metres. So it's not saying amended to clarify for A-frame signs.
That's correct.
That's correct, and so we would amend the definition of the criteria around A-frame signs to, if that was what got up the allowance for businesses within it to have an A-frame sign, regardless of,
A-frame signs aren't included in the 10 square metres.
I know, but they are included in the definition as you put up the amendment, the clarification on the definition up here, which didn't previously relate to 10 square metres, just said signage allowances covers A-frames.
Yes, you're correct. The allowances would, that general term would include the A-frame, so we would have to clarify it.
So this would then...
So
So we'd have to bring the matter of A-frames up separately with regard to the tenancy definition?
Yes,
I
they're two
think
different issues.
Yeah, if you resolved on the A-frames that you wanted to allow one A-frame per business within the tenancy, then we would need to then further amend this definition to make that, to facilitate that as well.
So just to clarify, and I'm clarifying the same thing Brian is clarifying, but I'm not sure we've gotten quite to the bottom of it. Earlier, when the motion simply said, amend the definition of tenancy and to not include sublet, not separate subletting, did that included the concept of the 10 square meters area, and it included temporary signs such as
correct.
We now have a recommendation here for amendment that this clause be changed to specifically talk only about the 10 square meters.
As my understanding, the purpose of this was to not exclude the sublet businesses from the definition. So the allowance of 10 square metres applies to the principal tenancy holder, and it's inclusive
it becomes
of the sublet.
Only this particular thing that we might be voting on is only applying to the 10 square metre allowance.
Can I make a suggestion?
It'll be the 4 square metres and the 10 square
I'm going
metres
to
as opposed
suggest
to...
that we deal with this similar to the other one, where we, rather than trying to look at this on the run, we get some advice just about how that definition. I'm a bit nervous about amending a definition that amends one part of a definition. Let's just make sure we get the wording right. So,
and as a mover, I'd be happy for that to go back and include with the consideration of that tenancy definition with regard to A-frames as well. This be looked at as to how it all comes down.
So my advice would be Councillor Juricevic withdraws that, and then we can get some advice from staff for Thursday night.
Happily withdraw that.
Okay, thanks.
Okay. The next amendment I'd like to move is that item C be amended to read as follows. To fund ongoing signage compliance through Council's general revenue, and this is the change, for commercial industrial properties and not an annual allowance fee, and refer to next budget 2021. And the question I've got for the CEO before that goes any further is that possible to do through a rates review? Is just an element added to industrial and commercial properties only without going across the general rates?
Sorry, can you just explain what you're trying to achieve?
What I'm trying to do is that if we're going to fund compliance, that those that fund the compliance are those who it relates to. And if it's going to be signage compliance, it should be the commercial industrial properties where signage applies, rather than the general rate base of households as well.
I would have thought there would be other signage that applies for properties other than commercial and industrial. That would be my first initial thought, whether it's home-based businesses or anything like that. Tourist accommodation would be quite different. Yeah.
I think that I thought that the motion that has been put to us has already removed the annual. Can you explain?
It's in there.
That's what that is.
That's correct, Councillor Jackson. So the proposed changes to the local law, as you can see in A2, remove any requirement for annual approval, licence and ongoing annual renewal fees for signage. So the proposal only requires approval for the reduced number of signs, which are pole, pylon, freestanding and illuminated. It was a one-off application fee and proposes to remove any annual renewal fees. But that's correct. The proposal already does that.
for me on the board the original motion from Councillor Parden that includes A2. Just highlight that.
So I have a question. So what we're currently looking at is amendment of A2, which is now called C. Is that right?
No, I was amending C to fund ongoing signage compliance
Okay,
Yeah.
So
through general revenue.
Okay.
One relates to the signage application, and the other relates to council's enforcement of it. They're
Okay.
slightly
That's
different
right.
elements.
Yeah. And so if we can go to the current amendment being proposed, I am presuming what's intended is not to fund ongoing signage compliance through council's general revenue, which by its name is general, but are you suggesting that there is an increase generated from commercial industrial properties? Because once it's gone in,
It's my motion.
yeah, so what it said, you say revenue for commercial industrial properties. We don't get
We do get a rate space. We get a rate space from commercial and industrial properties. We get a rate space.
it's generated by.
Generated by. Okay.
Not
The
for-
wording may be incorrect, and I'll be quite happy to amend the wording. This was what was given to me by staff when I requested it, so it's the wording has come from staff. But it's relating to where compliance applies to commercial and industrial property signage, that they are the ones that should be paying for the compliance, and not home properties or.
Can I make a number of quick observations in relation to the proposed amendment? Firstly, is that probably a discussion for a budget process, not a discussion for the signage about, because really what you're talking about there is changing differential rates.
Yep.
That'll be my first observation. The second is that I'm not convinced that all signage would relate to those properties.
Fair enough,
I think that's a debate you've got to have at the budget time, not at this time.
Would we be able to differentiate the compliance officer at that time? I suppose the compliance officer being put forward. Yeah, okay. No, I'll withdraw. Good point. I'm happy to withdraw that motion. You raised a good point there. You raised a good point there because the compliance officer would be a new budget consideration. How we fund the compliance officer is then for consideration there. So okay, no, I'll withdraw that motion. That's a good point. I hadn't thought of that. Thank you, Mr. CEO. All right. The next amendment. That item D be amended to read as follows. Permit teardrop flags at the rate of 1 per 20 metres of street frontage and not at the rear of properties backing onto a road. Do I have a seconder?
Could I ask a question first?
Yep.
The rate of 1 per 20 square metres of street frontage.
No, it's square metres, linear metres.
Sorry, linear metres of street frontage, and the not at rear of properties backing onto a road. Where did those come from? Is that something that already exists in any of the laws?
No, it's something I've come up with, and it's relating to properties that may, like on the industrial area, backing onto any creek road, that isn't considered street frontage, to differentiate the back of a property as street frontage to the front of a property, so that you don't then get a calculation of the rear of a property and an allowance of more flags as a result of that. It's strictly what is considered the front of the building towards as far as access goes. That was my intent.
Mm-hmm.
Whether that's clear in that amendment, I'm not. I'm happy to take.
I think that reflects your intent.
Thank you.
So I'm sorry, I keep asking, but so that implies that there are certain buildings that have two street frontages, the back street frontage and the front.
Well, there may be,
street
and a side street frontage as well.
Oh, okay.
Some may actually front the main roads. Others may be considered the back of house.
Right.
I'll give you an example of in the car yard area. The fronting onto Lionel Donovan Drive would be considered the frontage, in my view, and the rear facing Eni Creek Road would not be. So the consideration would be the lineal meterage along Lionel Donovan Road would be the rate at which teardrop flags could be set.
Do I have a seconder?
Do I have a seconder?
Yeah, I'll second that.
You can't.
Oh, I can't.
You can.
Well, I'll second it for the sake of discussion.
Thank you. Seconded, Councillor
Yeah.
Jackson. Look, you talked to it. Look, the current local laws as they stand, or proposed local laws as they stand, have gone to remove teardrop signs. I've heard it debated here a number of times. Again, I've never had a complaint about the teardrop signs, apart from a couple of councillors' perspective. But I've also heard a number of councillors supporting teardrop signs, that they are inoffensive, that they do add and in fact break up some of the more stark frontages that we have, and in amongst cars, it's not doesn't have a detracting appearance. For me personally, I don't find these teardrop signs offensive. I find them far less offensive than bunting, which was something that council never supported in the past. They're fairly insignificant, and I don't see the point of where a number of businesses already have them in place. I'm happy to support businesses to maintain those rather than have to get rid of them and no longer support teardrop signs. So that's my justification. Anybody else wish to speak to it?
I'd like to ask a question. Not being familiar with the total legalities in the local laws at the moment, is there currently something around you could either have an A-frame or a teardrop sign? Is that how it works?
That's correct.
So you can't have both?
Can't have both.
In the current local
In the
law?
current local law.
So
have one or the other.
in this case with D, does that capture that choice?
No, that would be an addition.
Yeah.
So you could have both? In other words.
Yeah.
I'm happy to speak to it.
This place is built on strict sign laws. Staff came to us when we started first looking at this with a couple of key areas where non-compliance was causing what the staff in their professional opinion was considering to be a reduction of the urban design and character of this town. One of the key areas was in terms of the proliferation of teardrop signs. That's what staff recommended they be done away with. We have to be very clear what has made Noosa different from the rest of the eastern seaboard. It is because we don't look the same. It is because we've had strict sign policies. I've described teardrop signs in the way they're used as the cane toad of advertising, because they have just proliferated beyond belief. To suggest that we go from the current policy of either a A-frame sign or one teardrop to one which might allow, half a dozen to 10 is a very big step backwards. It's saying we're not serious about clutter. It's saying we just want to be seen to be good to business, where in fact, if we look at the impact of our historic sign settings to be good to business, we want to have less.
Thank you, Councillor. Councillors, I've just noted that the Channel 7 news crew has got their camera in the room. I'm just seeing if everybody's happy to have cameras in the room. Are there any objections? And you are quite within your rights to object.
No, it's okay. I'm sitting this way so they don't get the ball spot this time.
What happens if object?
You can quite within your rights to object.
Yeah, you can.
Can we kick him out?
Yeah.
They need a second opinion. Approval.
No, alright, just leave it. It's cool.
Okay. All right. Thank you, guys.
I didn't go on the hair either.
Okay, so Councillor Stockwell has spoken to it. Is there any other councillors wish to speak to it?
I think I'll speak, perhaps feeling that this is another one that perhaps needs a little bit more consideration. I'm, like Councillor Jarusevich, supportive of businesses having an opportunity to put forward teardrop signs where appropriate. I haven't had enough consideration of whether 20 square meters, I don't know what that means at the moment. Somebody talked about 6 or 10, I don't know. And also, I'm not sure how that interacts with A-frames. Also, I mean, when I'm driving around the Shire, I see little businesses, home-based, selling eggs with a little banner saying, get your fresh eggs here, or things like that. And I actually want to be able to support, because if I'm driving down one of the roads and I see a flag, it can bring attention to something being available. So I think to not support totally tier floor flags, I think that's a bit counteractive to successfully and encouraging small businesses. There's another element to banner signs, which is quite a different sort of scenario, and that's what's called a car yard, where there are lots of banners. Funnily, I'm the one that's been arguing that I actually think it's better than a whole lot of cars without banners. So you know, I actually don't have a problem with those particular things. But I, at the moment, would have a preference to explore this concept of teardrop signs a little more, and we have time to do that by the ordinary meeting, which I think we could then look at how this can be managed so that it's not just specifically. I'm a little unclear about what exactly the outcome is here, so it's hard for me to support it without that clarity. Yeah.
Councillor Parton.
Yeah, Mr. Chairman. Look, I agree with Councillor Jackson's comments there. It's not clear, and we've talked about precincts with regard to industrial estate, and I agree with Councillor Jackson with regards to teardrops, signs, etc. I agree that to me they look better than just a heap of cars on the front of the road, so it sort of adds to the character. And so when I refer to precincts, once again, an industrial precinct with that type of teardrop, when it's 1 at 20 or whatever someone picks, that's not a lot anyway, 1 every 20 metres. That's a fair run, 20 metres. So you're not putting a lot up there anyway. But I agree with those comments that they don't offend me. And in a precinct like an industrial estate, it's less offensive to me. But having said that, what's before me doesn't cover the whole with regards to signage, so I can't support the amendment in that regard. Councillor Stockwell's comments in the big picture, quite right with regards to we have to be careful what we're doing here with regards to the visual clutter of the whole Shire, and I agree with a lot of those comments. The only thing I disagree in the fact that, well, I guess I agree that staff went out there, did an audit because we asked them to, and most of the people, about 85%, were compliant anyway. So I was never looking at causing a problem with regards to whether it's teardrops, signage in general. And it's all right as a consensus of council, or whatever the decision of the majority of council is, or councillors is. Staff have a view, and that's fine, but we make the decisions at the end of the day, and staff can bring me any report they like, but we make the decisions here, and staff might have a completely different view, and at times they do have a different view and see the world differently to us. So I just make that point as well. But on the face of it, what's that amendment that's up there, I can't support it.
Can I have a question?
Please.
So the 1 to 20 linear metres, does that mean that something like the cafes and so forth in front of this, say Kimby Terrace and so forth, that only got quite small shop frontage, it wouldn't occur there?
They'd have one.
One, that's
Up
it.
to, so up
if
to
they had
20
a 21 metre linear metre cafe,
could
they
have
could technically
two.
have two. Could we possibly make it longer, so the car yards and stuff?
You could move an amendment to.
You can't amend the amendment.
You can't amend the amendment.
Yeah.
You could, well, if it was defeated,
we could all agree that
1 per kilometre.
one on this, but we could all agree that, you know, the car yards and the sort of industrial style uses are all longer than most cafes and type uses in Noosaville and so forth, and we could argue to have them there, is that right? But not the cafes?
Who are you asking the question of?
Staff, sorry.
I think that's
Probably one to me.
Oh, better Joe, yeah.
Look, the figure of 20 metres was a nominal figure I picked. I looked at most commercial spaces and industrial spaces, looked at where teardrop flags are currently being used, and I picked a nominal figure just as an arbitrary point to start at, to at least enable the opportunity for teardrop flags to be considered, because at the moment in the draft they aren't being considered, they're being excluded. I think there is a place for them, and again the 20 metre street frontage meant that your typical, you know, we were talking about one A-frame or one teardrop sign. I thought one teardrop sign in the industrial area, for example, out the front of a car yard was probably a bit minimalistic, and I saw scope to increase that. But I saw where we've got a number of smaller tenancies, perhaps out front elsewhere, that they don't exceed 20 metres, and so that would enable them to have the one sign. I thought that would bring in the restriction of one sign for smaller tenancy areas, but where there's a larger tenancy area, some more flags could, some more of those flag signs could be
Are you speaking to the motion? I'm talking to the question.
That's where the 20 metres came from. And so the scope of allowing that area to increase or decrease was an arbitrary figure that I came up with, and it could be argued either way to increase or decrease that figure.
So I can't make an amendment to the amendment, can I?
No, not at this
so
point.
I'll speak to the motion. I'm on the fence about it. I'll need some convincing, team. I'm not convincing. I think there's merit in what you say, totally. I don't like the idea of teardrops being littered in our more pristine areas. Teardrop flags, sorry. I don't know how to jump on the fence and go, should we do it between businesses up 20 metres and over? We can't do that now. Could you maybe think about that? You know, chucking in 20 metres and under, because you're going to get all those smaller type ventures up doing this, where we could agree that, you know, box shops and car yards and so forth, it's very apparent. I actually know through teardrops is good on car yards because it defines where the cars are. Toyota, Holden, blah blah blah. So you can get around easier. So there's a winner for me. But you know, I have to be convinced.
Question for staff. Now, when Councillor Jackson alluded earlier about there being no A-frames and no teardrop signs in the current draft.
In the revised draft that's in the report, we're proposing to continue with the prohibition of teardrops, so none, but allowing one A-frame per tenancy on private land, so not on public land.
So where we don't refer to A-frames and teardrops in the same sentence, my bringing in that amendment just to point D. D would only refer to, that would keep teardrops as a separate entity, separate.
That's right. So it would be
something
an
completely
addition.
separate. So it would take a change elsewhere to have the option of either an A-frame or a teardrop.
Yes, we would run with the similar style drafting now, which in the a combined A-frame teardrop provision where you could have either or.
All right, well, that's something that could come back before Thursday's meeting if this is defeated here in that regard, because that's not my intent. My intent wasn't to to be an addition. It was to be in the same manner as to be one or the other, as it had previously been in the laws. It was just a ways and means of giving a definition as to what was permissible and preventing proliferation. So. Thank you, and I'm essentially speaking to my closing arguments there. Again, that was the intent, was ways and means of raising some sort of a median, some sort of an option to allowing these, but to prevent the proliferation of these going forward, and giving some definition. The 20 metres was an arbitrary figure that I picked based on the fact that I thought most of the commercial tenancies would preclude them from going more than one. It was never intended to be teardrops as well as A-frames. It was supposed to be teardrops in or A-frames, as has previously been the case if we decide to go down that path. In the event that A-frames don't get up, then that may be an option. But again, that was a ways and means of at least discussing the option of teardrop signs, their proliferation, and how we may be able to deal with that. I mean, there is scope for this if this is defeated, for that to be reviewed and looked at before Thursday night's meeting as well. So I'll put the motion. Those in favour? Those against? That's Councillor Glasgow and Juricevic for, and Councillors Pardon, Jackson and Stockwell against. The motion the amendment is lost. And I've got a couple more to go.
Should order lunch.
Okay, the next
Or
amendment.
dinner.
We'll keep going. And this may, I may have to review the figures on this, but that a new item be added, A12 or 13, sorry, AX11. Be added to read as follows. Just the first one. Thank you, Kylie. And having talked to Anita, there may be a better way of defining the glazed area without the door.
So currently,
I suggest you read out.
Read out what's there.
Read out what's there. First.
Allow a maximum of 80% coverage of the glazed area of the building. Exclude product images representing the goods sold on the premises from the sign face area calculation.
So currently the reference to, it doesn't refer to windows, it refers to the glazed area of the building. So any part of the building that's glazed, so it includes the doors or any upper level. And the proposal here was to suggest 80% coverage of the windows, excluding the doors. Was that correct?
That was supposed to be 80% of the glazed area.
Glazed area.
Excluded, excluding the door for safety reasons. And I picked the 80% trying to come up with an arbitrary figure of which the door would be in relation to the glazed area. But I realise now that that probably isn't an adequate description. I mean, how you differentiate between the windows and the doors in a glazed area is the question for me now.
Oh, well, we would describe that specifically.
Well, I would say 100% of the window area excluding the door.
Can I make a suggestion? Maybe just clarify what you're trying to achieve here, Joe, and this might be another one.
One bring back to
you have to
Thursday
think
night.
about whether you withdraw this and come and debate it on Thursday night.
Yeah, all right.
Maybe just explain exactly what you're trying to achieve.
I said what I'm trying to achieve here is enable to differentiate between imagery and wording, which I think signage is intended to define. Wording and logos, I think, are what signage is intended to define. What we're seeing more and more, promotion of a business through an image on a window, and a window image to me is no different to a product display, and a product display can be put behind a window. So I'm trying to find a ways and means of using the more modern type of graphic design work that we're seeing on building windows as something that we permit and allow, rather than calling signage and not permitting. And I think there are some good examples around town of that, and some that have been critiqued and accepted quite widely by the community. So that was what I was trying to show.
So my suggestion, that's up to you as the mover, would be that you withdraw this and we get some more information about what wording we'll try and achieve that.
I'm happy to withdraw that and bring that back on Thursday night with regard to the wording of trying to define window and door separately.
And I think I've mentioned before the question from Councillor Stockwell. I think at the end of this debate I'll do a bit of a summary of some of the issues where you might need more information or more wording for Thursday night.
If we put
I'll
that
summarise that, and we might end up with another report, and I'll just come back at the end of this debate.
Well, similarly, my next.
Can I also just advise council that that reference to window coverage of glazed area is actually in the planning scheme, not just this. It's not just the local law and signage.
We'll have to go back and get some more information.
It would actually require a change to the planning scheme.
Okay.
But that's the information council will need for Thursday.
All right. Well, then my next amendment refers similarly to with regard to LCD screens and window signage. I think I'll take that on notice as well and refer that to the review that you're doing in that regard, rather than amending it. There are two other amendments. That the second last one is that a new item A15 be added to read as follows. And it's to increase the number of community service organisations for sporting club sign-on days from 6 to 10. Kylie, can you change with 6 permitted within 5 kilometres of the club and 4 permitted outside the 5 kilometre radius? The reason I've changed it from 6 and 4 is because 6 is what's currently proposed in the draft local
Can I
law.
suggest that you read that out for those who are watching on the video?
I thought I did.
Okay.
Did I not just read? Did I not?
I thought you just summarised it.
Sorry. Increase the number of community service organisation signs for sporting clubs sign-on days from 6 to 10. Because 6 is what's in the current draft, with 6 permitted within 5 kilometres of the club, and I believe that's the parameters that are in
and
in the
keep
draft,
going.
and 4 permitted outside the 5 kilometre radius of the club.
May I ask a question?
Please.
What is permitted right now, staff? Could explain. What is permitted with respect
In
to
the draft?
community service organisation signs for sporting club signs?
Ingrid, are you asking about what's in our current local law or what's proposed in the draft?
Actually, I'd like both.
Yeah.
Yeah.
Yeah, good. So, can you just both what's in our current local law and what's in the proposed local law in relation to the
So currently, in the current local law, community service organisation signs don't specifically reference sporting club signs. So in the draft local law, we have specifically referenced sporting club signs with specific provisions around that. So currently the local law is silent on the sporting sign-on area. So it's a new
But
provision.
we do have a definition of area in the new draft, as I understand it.
No, it's a community organisation. Yeah, so in the draft, sorry, so many. Sorry. So yes, in the draft, we've included specific reference to sporting sign-on days, and the number must not exceed 6, and the area is the advertising device must not be displayed outside a radius of 5 kilometres from the site of the sign on a day in a coastal urban area or outside a radius of 15 kilometres from the site on the sign-on day in a rural hinterland area.
What was the first one? 5?
5 kilometres from the site within the coastal urban area and 15 kilometres in the hinterland rural area.
While you've got that, does it talk about timing in there, or how long it can be up for? Or anything
So
like that?
the advertising device must not be displayed more than 14 days prior to the sign-on day and removed within 24 hours of the conclusion of the sign-on day.
Is that clearer, Councillor Jackson?
Just clarifying, so the only change from what you have proposed here is
The number of signs.
increasing the number of signs from 6 to 10, and also
Distance.
changing the distance, and I assume that's in the coastal area, from 6 within 5 kilometres and 4 outside the 5 kilometres.
whereas
Whereas the current definition defines
Won't
it to
allow
not
outside
outside of
5.
15 kilometres.
that's in the hinterland.
Yeah.
And in the urban, you couldn't have outside
the
of 5.
Yeah.
correct.
Thanks, that's good. Thank you for the answer.
Okay.
You
Do we
need
have?
to check whether there's a seconder.
Do I have a seconder? That's the question. There being no seconder.
I'm willing to second just for the sake of discussion.
Oh, thank you, Councillor Jackson. Well, then I'll speak to the motion. I thought the definition of staff out was a bit restrictive. What it did is that it meant that sporting clubs that, as I read it, sporting clubs that are on the coastal fringe couldn't advertise a sign-on day in the hinterland regions, and vice versa. I thought there was some restriction there. I thought it was easier to try and come up with a set of parameters that I thought were more readily able to be understood, and also to permit some more signs, because six within 5 kilometres is great for that, but then there's no allowance to go beyond that, then go and place one in each of the hinterland towns, which I think when a sporting club such as the soccer club at Girraween puts 6 around within 5 kilometres, there's no way that they can attract hinterland residents or hinterland members to the team readily without then taking those ones close to their premise. So I was just trying to give a little bit more allowance to clubs during that 2 weeks to reach a wider audience within the overall Shire region. I thought the 15 kilometres in fact prevented them from reaching some of the hinterland towns. Kin never get a sign.
Mr. Chairman, look, I'll support this. Sporting clubs, I'm always in. And it doesn't seem to make a lot of difference to me. The difference is or what I don't like the idea of the division, the hinterland and the coast, never have, and so form permitted outside that radius. I mean, pick a number, but I think that radius would have been better. I would have thought that there's no particular radius. People want to advertise their clubs, sign on days for the kids wherever, given the timing, the 14 days, etc. I would have thought that, from my perspective, that's fine. I mean, that's who we are, community here. 80% of the people either play sport, referee it, visit it, take the children to it. It's a big deal, and for this one, this is a big social issue. And good. I think thanks for bringing that here. I think it's commendable, really.
Any other councillors wish to speak to it?
We've got a conflict of interest with your example. If there happen to be two sporting clubs of the same code in the same division, I think a hinterland club would be really annoyed if the coastal club went and put a sign-on day up in Karoi, for example, outside the Karoi Sport Complex. They can go and sign on somewhere else where we. I think that's what we have to worry about, is that where there's only one code, we don't want to create turf wars between here and there. None of the clubs that I've been involved with ever use them. I think we're forgetting that these signs are towards the edge of ineffective. The most important sign any club or any business can have is about that big, and it turns up on your phone. And any suggestion that this is a great thing about it, very little. It's, to me, I don't like the concept at all of signs on roads. I can understand for events, and I can understand for a short period for sign-on days, particularly in rural areas where it is, people in Karoi might know that there's, an AFL club in the other town. That's probably a useful sign. But around the coast, so we don't need 10.
Any other councillors wish to speak to it? Again, 10 closing argument. 10 was an arbitrary figure. 6 was permitted within 5 kilometres, and I just thought that became restrictive. If we permit 6 within 5 kilometres, and I agree with Councillor Pardon. I think the limitations with and that's probably what I should have looked at, removing the limitation of the kilometres where the signs can be spread. But I think 6 is fairly limited. I don't think 10 is overstretching, and I think this is intended to support community groups from getting membership, as well as the obesity issue and all the rest of it. Getting kids engaged in sport in some way, shape, and means of promoting that. I mean, not everybody does do all the research and the look-up. Not everybody does know when the sign-on day's up. Not everybody's aware of all the clubs in the region. So an opportunity for those clubs to just flag themselves for a couple of weeks across the entire Shire was what the intent of this was, and that's I think in supporting our community groups as much as I possibly can. So I'll put the amendment to the vote. Those in favour? Those against? That's Councillors Pardon, Glasgow and Giroux speaking in favour. Councillors Jackson and Stockwell against. The motion is carried. I may review that before Thursday night. And the last item I've got is a point G, and that is to undertake a further review of advertising devices when the signage audit is complete. My understanding is the signage audit is still being undertaken.
That's correct.
Thank you. So that's the reason for moving that, so that when we've got all of the information, I'll put that first and ask for a seconder.
I'll second it.
Thank you, Councillor Jackson. Speaking to it, I've said my intent here is that once the audit review is the audit has been complete, that we can have a full assessment of compliance and any other issues that are brought forward, and then we can go back and review based on quantitative information and quality of the information provided, but that the audit should undertake. The audit to date has given us a reference of something like 85% compliance. One of the reasons I've objected to a number of the new parameters in the draft signage laws is because they are changes that have been done without necessarily an audit being completed. 85% compliance tells me that basically, the rules and regulations that have adhered for many, many years that Councillor Stockwell alludes to are in the main adhered to and appreciated and respected in that regard. There is only a small element of compliance, and we don't know what element of that 15% we haven't had it clarified. That could be the teardrop signs, that the excessive teardrop signs might constitute 10% of the 15%. I don't know. I haven't got those figures in front of me. So until that comes back before us and we've got clarity of that, I'd like the opportunity to, once that's complete, to go back and have another look and see if there's areas that we can tweak, amend, or go, guess what, we've gone too far. There was never any need to go there because nobody did, was not complying with that, or this is the element where the most significant non-compliance is, and just work on that area. Councillor Pardon.
Yeah, I'll support that amendment, Mr. Chairman. I would have thought probably staff down the track have thought of that, having a look. And the points you make are valid. The only thing I'd point out is, and we know that's why we've had an audit. We've had a lot of slippage in the past when we were amalgamated, and there has been slippage and there has been some creep, not to a great degree, as you point out, but we're trying to hold the line here in Noosa and do improvements where possible with regards to signage. That's why we're doing local law. Over time, things drift a bit. But you make a good point. Many of our shoppies around the town, various centres, industrial centres, have listened to our officer going around and have made changes. I know that for a fact. So how many are non-compliant by the time this law is even enacted? It'll be interesting. But look, in the main, I'd have to say I would have thought that we've got a lot of feedback. We've copped a lot of flack, I guess, over advertising devices and signage and proposed laws, etc. And I would have expected that on some of the issues. But some of the issues there's been great support for, and the general public, I'd say, is supporting council's endeavours to try and hold the line and actually, do some regulation with regards to signage to stop creep over time. So, but yeah, I'll support the amendment. I think it's good, and I think it was obvious that we have a look in the future going forward anyway.
Any other councillors want to speak to the amendment?
I'll just say that I will be supporting the amendment because I think any further information that can help council have really good quality rules that work for the community is a good approach.
Thank you. Anyone else? I'll close and I'll follow with that sentiment. I think this sends a clear message to the community as well that we haven't closed the door. These drafts are there, but once an audit's complete, there is room and scope to go back and review these and see that the changes that have been made do or don't work, and also see the effectiveness of the audit. I think one of the clear things that the audit has brought is the level of compliance, and as Councillor Pardon alluded to, that having a compliance officer speaking to businesses and an element of education is obviously having some impact, and the level of compliance, as I understand it, is further being enhanced by that process. So I await the final outcome of the audit to see if there is any further action needed to be taken with regard to signage in the future. So those in favour? Carried unanimously. Thank you. All right, we're back to that's the last of the amendments. We're back to the original motion. There are.
And only Councillor Pardon has spoken to the original motion.
That's what I've got.
I shall speak to the original motion in support of the original motion, and I'd like to start with a general statement that I have been very happy to see the work the staff have done in order to respond to the feedback from the community and from the business community about this. It's very important to our businesses and has a massive impact on their ability to attract customers and costs, and I've been really appreciative of the responsiveness. I think I think the amendments that have been added today and Councillor Hardin's alternate motion, which has some slight change, are all constructive and responsive to the business community also, and I strongly support this motion.
Councillor, anybody else?
Yep. So, councillors, I think we're going backwards. I think when I went looking for evidence to support anything different to what the staff recommendation, I spent a couple of hours looking through the literature trying to find evidence that A-frame signs on footpaths work. I couldn't find any. So I went to the main evidence. The main evidence is this document here that was in place between 1986 and 1997. And it had settings almost identical to what the staff have recommended. And that decade was where Noosa's brand was established as far as urban design was concerned. This document here is what established the ethos, that when people came to Noosa, they experienced something different. They didn't walk down Hastings Street and have the same retail experience, or whether it's a junction, that there was something different. It was uncluttered, it wasn't cityified, it didn't have banners everywhere, it didn't have block walk paths, it had open air dining, and it had an experience. Now, I have gone out publicly and had my opinion on this, and interestingly, David Nicholson, who was one of the original members of the committee that wrote this, he's a designer assistant, he took the opportunity to email me, and I thought, well, if there's no evidence in the scholarly literature, maybe evidence from a professional would come in handy. And he's lived in Noosa for a long time, and he said, I have a vested interest in this matter. I was the original Noosa Shire Advisory Design Committee in 1986. Okay, I'll keep on going. In my view, even with the passing of time, the core values and messages are still sound of this document. And the Noosa Shire has retained its unique character, which is this day still attracts so many visitors. As a design consultant for many years, working mainly in the area of architectural signage and graphics, I've been involved in numerous projects for both the Noosa and Cooloola Shire Council, as well as several architectural practices and developers. This has put me on both sides of the fence when dealing with this issue of public and wayfinding signage. I have always managed to convince my commercial clients that less is best. All good planning and policy need to be revisited from time to time, and despite some minor tinkering with council signage policy over the last 30 years, the current document basically remains true to the values outlined in the 1986 manual. It is only one policy, but an important one. When developed responsibly, can only assist in maintaining the core values of the Noosa brand. And councillors, I did find something in the literature about the Noosa brand, and it was a study done by the University of Queensland Business School at Tim Brailsford. And while it was an experimental approach or exploratory approach, what his research showed that the Noosa brand just about doubled on average restaurant and accommodation business compared to the Australian average. He had pointed that if you were a business in Noosa, the brand doubled your likely income. But retail was only about 20%. Now, it might not be double, it might not be, but we do know that doing business in Noosa and setting up business in Noosa, you come with the added benefit of having a community that has respected for certain values. To me, councillors, we have to be very careful when we consider this, that we don't start just letting things bit by bit reduce those high standards. And it is that death by small 1,000 cuts that we have to worry about, because that's how all the other towns along the East Coast have got there, because they've just kept on just being a little bit better. And unlike a number of councillors, everyone who's been emailing me has been about in support of a strong approach. And it's not just the design consultants are saying it. We know, we've all seen the letter from one of the biggest employers in our town, where he employs 250 people. And he says that it's critical the council does all in its power to maintain the character and the look and feel of Noosa. And the items listed as prohibited devices, including A-frames and revolving signage, etc., creates the visual clutter and significantly reduces our general amenity. I agree with those two gentlemen. I believe it is really important between now and Thursday that we really have a think about, are we listening to the majority, or are we listening to those vocal few who perhaps don't understand the importance of having less is best as our signage policy.
Councillor Barr, you've already
Oh,
spoken.
yeah, no. I thought you want me to
He gets a
close.
chance to come back.
No, not yet.
I'll
Okay,
just
Councillor Gaspar.
I'll just say quickly, all the emails I got was about staff and how you went back and actioned it and revised it, looked over what you've done and brought back to us this masterpiece in front of us. So, you know, it's never ever perfect, but I'd like to say it's a lot less than what Councillor Stockwell says. It's not perfect, but it's you've come back and you really critiqued it great. I think we're at a good compromise here for various contingent sides of volunteers. So thank you.
Finished, thank you. Well, I'll add my 2 cents worth in here. I don't know about going backwards, Councillor Stockwell. The Noosa brand is important, and it does provide that. But if businesses can't be found and can't be located and don't get the opportunity, they don't get to do customs. So I think there's an element of what we've been hearing is that the businesses still want their opportunity to be located, and that's with clarity and with some options there to individual. I think that brand is respected, and I think that comes with the element of the audit that are being undertaken with a high level of compliance. I think most businesses appreciate and respect it. I don't think there's any challenge there. But some of the things that were proposed were going beyond where we currently stand. And again, that high level of compliance shows that there's an amazing level of respect to what currently exists and the differentiation between Noosa with regard to signage and elsewhere. But there's still scope to then try to find some sort of a compromise that does allow business to undertake business the way business should be undertaken. And that's all businesses have been requesting in this, and that's why there was such vehement opposition to the vast number of changes that were being proposed here, but also a level of voice there of a lack of understanding of the current signage laws that exist. And I think that's the small minority that don't comply currently. And it's a matter of education and better responding and better informing those business operators with regard to what is permissible and what's not permissible in the Noosa region, and that it is different from other areas, and that even franchises like McDonald's have complied in the past with regard to differentiating the way that they operate here in the Noosa region. It doesn't mean that we have to restrict signage to the point of nullifying it, but it does mean we have to manage it and manage it well so that all businesses do have an equal opportunity to display their wares and their prominence and be able to be located readily within the region. One of the ways of doing that is, as you stated, less is more. It's an understanding that clutter doesn't define your business. Clutter turns around and loses your business. Clear, concise messaging in a format with minimal signage is the way to go. But everybody should be allowed to display that signage and be found in the same way, shape or form. So that's where I'll end it, and I'll leave it to Councillor Pardon to close.
Yeah, thank you, Mr. Chairman. Yeah, I will close. And thanks, staff. Absolutely. I mean, what a job trying to sort this out. The CEO was correct. There's a mayor and 6 councillors, and there's 8 different opinions.
80.
And out in the community, my God, there's a raft of different opinions with regards to this. And Dave Nicholson, Nick, I owe him. He dragged me out of a fruit shop to play rugby union and got the hell belted out of me to launch the Noosa Dolphins. And in fact, he got the hell belted out of himself. I think he was the only one older than me playing in the old days. And I have a lot of respect for Dave. He's a good bloke. With regards to brand, it's kind of interesting. So you're right, Councillor Stockwell's right. Over many, many years, the Noosa brand has been through planning strategies by its people long before. I've been here 38 years, but they came before me as well, and looked after the place and managed the place. And that brand has grown into, we know, international brand now. It's a big brand. And then it depends on your circle, see. some people now got to the state, done such a good job, there's too many turning up. That's another conversation, interestingly enough. We're so popular that we can't fit them in anymore. So I don't think A-frames in front of shops have destroyed the Noosa brand or would in the future. I think that's drawing a very long bow. And for me, the Aussie knockabout and the circles I move in, and I understand we all have our own circles of influence, councillors, and I move in business circles as much as the wider community. And I can tell you where business sits with regards to this council, out there looking at us. And I'd suggest people move outside of what their little circles are and get wide across the community. Otherwise, there's already been some backlash with regards to signage. And I know some players here that are big owners of property. But if we look at the rents they're charging, that's why people are out there struggling and fighting for signage and every dollar they get. And this is not only a Noosa problem, of course, this is an Australian problem, probably a worldwide problem. So I'm not going to impinge them. The motion I moved originally, the part of this motion, and the only thing I die in the ditches for is allow them to have a little A-frame if they choose. If that's going to upset the whole brand and, you know, Noosa, its look and feel, I'd be surprised, because it was allowed in our planning scheme, and I don't think it's done us any damage at all. So on that one, I'll let them die.
Thank you, Councillor.
Mr. Chairman.
I'll put the motion. Those in favour? Against?
You've got a call.
So that's Councillors Pardon. I am. Councillors Pardon. That's all right. I can remember. I can remember where your hands were. I don't need reminders. Councillors Glasgow, Jackson, Pardon, and Jurisic in favour. Councillor Stockdale against.
Councillor, just before we move off that, I said I'd give you a summary at the end in terms of what more information might be available or needed on Thursday night for the council meeting, bearing in mind this is only a recommendation to council. There were 5 issues that arose during that debate, some of which were withdrawn, but I think it would be beneficial to have some more information. I'm going to suggest to Ken that we have a report on this on the agenda.
Thank you.
The first 2 are actually interrelated, which come to the motion that Councillor Jackson originally moved in terms of definition of tenancy and A-frames and what that definition would apply to in terms of A-frames. And the second one was the Councillor Jurisic moved also in relation to the definition of tenancy and dealing with the inclusive of sublet. So I'll get staff to give some advice to council about how that can be, those 2 issues can be dealt with.
Thank you. Is it possible to get some legal advice here with regard to leases and subleases as well?
The third one was about the wording that Councillor Jurisic used in terms of the teardrop flags. That amendment was actually lost, but I think the question arose about whether or not there would be wording that it would apply differently from having one A-frame or one teardrop. The question there is what wording would allow that.
I think the other possibility came up there with regard to differentiation of where teardrop signs may be allowed with industrial area versus commercial spaces.
Yep. And also the definition of glazed area and doors and how that might work and issues around that, and that's the differentiation between images and words. The other one that came up, which I think won't necessarily, I'm just checking on this, I think, won't need to be revisited on Thursday, even though it was withdrawn, was the question of funding out of general rates. I think that's a budget issue rather than having that on Thursday.
I'm happy for that, and I think you clarified where that funding would be.
If I can ask Kim, we'll arrange a report on Thursday. If I miss one,
there's one little thing that I think needs to be included in the report, and that is that when we were discussing the definition of tenancy, in the back of, I asked the question about which properties this would affect. There was discussion or response from Anita that some work was being done on buildings that were one tenancy but had a whole lot of sublets, and that would be treated differently. And I think if we're looking at tenancies, that needs to be in the report as well.
So what we'll
Because
do
it's
is identify the types. We won't be able to identify in every individual building in the
Sure,
ordinance. So
I
it's the type or the
understand
categories.
that,
I
but I
think
think
is probably a
there
better way
was
to
an
put it. Yep.
implication that something that was not in our list of things
Yep.
we're not in the motion was in fact being looked at by staff to be changed. So I think that should be
Yeah, good point.
there.
And I'd add to that, I mean, there must be some understanding from the audit as to how many potential sublease area or areas where subleases may be more prevalent than others. I mean, are they prevalent in the industrial area? Are they most prevalent along the riverfront? Where are they?
Yeah, they occur in both the industrial area and the river. I'd have to have a look to see whether we've got those
you might be able
actual
to give
figures.
some. You might be able to give some.
Might be able to give some examples.
Yeah, examples. Yeah.
Okay.
All right.
Can I thank the staff for working through all the detail? It's
Yeah.
been great work. Well done.
Well done.
Yeah, thanks for your patience on that, guys.
I think, and the response from the Municipal Business Association say that, you know, in general the business community was happy with that, to see that you did listen. And certainly when I met with them and the Hastings Street Association, they were also very appreciative of the approach you took with talking through what your response to the submissions were. So well done.
Thank you, guys. Okay, we'll move on to item 2 in the General Committee agenda, which is reports to public question time guideline. Councillors, questions for the CEO or?
I just have a very small question to the CEO.
Yep.
And I do appreciate that you have already asked for our feedback and that you've been working on this with consideration of that. Something small that I noticed as I read it on the agenda is that people are invited to either lodge their questions by email or by walking into the building and handing them in. What happened to sending things by mail? Is that
I'm probably a bit. I thought I was old-fashioned. Yeah, look,
you gotta hitch your horse to a cart.
I'd suggest the postman does that. He brings them in, and the postman would bring them in and hand them in on behalf.
We've got a box.
Yeah, I think mainly it's because wouldn't know when the timing arrives. If it comes into my office through the system, so to speak, if someone writes in on the Friday or whatever and comes up to me by the Monday, that's fine. But if someone posts it on a Monday and it arrives on a Tuesday,
if it's clear that it has to arrive 3
Yeah.
days before,
yeah, and
that
that's
is
been received, so it's a receipt.
it has
not
been
the sender.
received.
Yeah.
And I think that word "received" is in there
It is,
anyway.
yeah.
So I think I don't think this needs an amendment. I think this is something
It's just
we
a
can-
practicality.
Yeah, I would suggest adding
Yeah.
mail.
Okay. No other questions? Somebody want to
I'll move it.
Move it?
Yep.
Councillor Glasgow?
I'll second it.
Seconded Councillor Stockwell. Would you like to speak to it, Councillor Glasgow?
No, I think it's really all been said in this.
Anybody else like to
Yeah,
speak
I'll
to the
speak
motion?
to
I
it.
would expect. I would have
yeah,
fully
you would have thought I would.
fully
Well,
expected it to come
Absolutely.
as the person that
Yeah.
brought the matter forward.
That's right. So
Yes.
I'm really excited that this is something council has agreed to, and I had raised this as a sort of adding to our responsiveness to the community and transparency. So I'm really excited that this is going to happen, and I think the guidelines are going to be helpful. Clearly, people have to understand how the process will work and what's allowed and what's not allowed. And like what Councillor Jurcevic was saying about the signage, we're also going to be able to test it once we've used it for a while, and we'll know if it's working well for us. But I think it'll be great to be able to invite people to ask questions of council, and that it'll be minuted in the minutes, which I think is also a valuable element of this guideline. Thanks.
Yeah, Councillor Parton.
Yeah, I thank Councillor Jackson bringing this forward. I don't have a problem at all. Never had a problem with questions. Probably me downfall. I always tell them, ask me anything, and you get some interesting ones. But it's fine. There's certain protocols the CEO's written out here, and I think that's fine. And I understand Councillor Jackson. Well, I think I did just put some input into it as well, and I think that's good. The interesting thing about question time, the bloke that came in here to shoot a councillor one day and got me by mistake, at least he might be able to ask a question, which councillor he needs to shoot and get the right one going forward in the future. And I was warned after the meeting, which I thought was a bit crooked, but anyway, I think that's part of the democratic process. Be interesting. I'm sort of interested to see. We put this out here and see how it works. That's the proof's in the pudding. I'll be very interested to see how this goes. Thank you, Mr. Chair.
Councillor Stockwell.
Just a question: if it's adopted in this round of meetings, does that mean this commences in November round of meetings?
Correct.
Nothing further?
No, I think as I said last time when this first idea came up, I had some reservations, but I did go out and ask the question, and people thought if there was this opportunity, if they'd exhausted the other opportunities to get their questions answered, and they want to come straight to the political level, that this was, and I suppose the guidelines have alleviated any concerns I had about what it could potentially turn into. So I'm happy to support it.
Likewise, I'm happy to support it. I think there've been a raft of change, and change doesn't come easily to any entity, any organisation, or that. And but going through due process and the parameters around this, I'm highly supportive of it. I think there's always scope to broaden your horizons. I think there's always scope to listen and to adhere, and there's always scope for clarity and transparency. And I think this is part of that process that Councillor Jackson has been alluding to through her time on council, and I congratulate her for presenting this idea and option before us. And I think it's a great new initiative, and I look forward to seeing it in operation, seeing how we deal with it. Councillor Glasgow, do you wish to close?
Yeah, just quickly. I congratulate my fellow colleague. Very progressive. I like it. Transparency, very good as well. And reiterates how progressive we are as council, and I support it wholeheartedly.
I'll put the motion. Those in favour? Carried unanimously. Thank you. Item 3, financial performance report.
He's on his way.
He's on his way? We'll just wait for our finance team member to get here. Thanks, Kim.
Trent's on holidays at the moment, that's why you got Michael today.
Okay.
The boss.
Unless you want to start, or
Well, any questions or comments anyone wants to? There's no question at the moment. Oh, here he is.
Oh.
There you go. Perfect
Yeah,
timing. Right on time. Councillors, any questions or comments?
I have some questions.
Fire away.
Yeah, okay. One is that I noticed that Noosa community support fees are below year-to-date budget by 13,000. And then later I noticed there's a reduction in annual grant funding. Is that the reason that we're below budget?
No, they're separate issues.
They're separate issues?
Yeah.
So what is the reason for the running below fees, support fees?
Look, I'd need to take that on notice.
Okay.
And
Don't
talk
know
to
that.
Perry, Contini, the director,
Okay.
investigate that.
Yeah.
That's not an issue.
You may have difficulty answering my next question then, and that was around, there's been a reduction of 10,000 below budget of property change ownership fees. And that seems to indicate fewer sales, 19% fewer sales than expected.
Potentially, yeah. But obviously it's all market driven, isn't it?
Yeah.
Change of ownership's all owed to property sales, so
Yeah.
we'll just keep having to monitor that
Yeah.
and then determine whether we need to make any adjustments at a future VR. But generally we've been tracking. We did slightly increase the budget for property search fees and change of ownership this year to reflect previous years where we have come in over budget. So we might have been a bit optimistic. We'll find out.
Yeah, no worries. What about waste disposal fees coming 86,000 below year-to-date budget? I wonder why that would be, given that that seems like a standard fee.
Well, waste disposal it's based on volumes. It's not a standard fee.
Okay.
So they're fees over the weighbridge. So it could be green waste disposal, general waste disposal.
Okay.
So look, it's volume driven, so we need to monitor that as well.
Maybe an element of curbside cleanup has just been undertaken?
It could be, but also obviously the waste levy is having an impact over the gate for commercial waste. So there's we did expect some sort of impact there in terms of maybe waste not going over the weighbridge.
That's an interesting question that comes up there. Is what impact? I mean, I said you've got no idea volume-wise what we've got been going through there, but is the waste levy? It mentions the waste levy timing here, but to resolve, is it an element of the waste levy that could be having that impact there? I mean, is it people are holding off to see the impact of the waste levy, or they're getting there and finding out? I mean, has Australia given us any indication as to whether there's been a lesser volume of traffic coming in since the waste levy was implemented?
Look, I haven't spoken yet to waste regarding year-on-year volume movements, but that's something we can look at.
I mean, volume versus movements are two different things. I mean, are we still getting the same number of movements in?
You might recall that Wayne does a detailed report to council every 4 to 6 months on that, and I think the next report will cover that.
Okay.
The volume and movements they're directly correlated. So.
Sorry, Councillor Jackson, didn't mean to interrupt there. I just wanted to continue on that train of thought. Have you got some more questions?
Yes, I have a question of the CEO relating to staff salaries down and overtime up quite significantly. Under expenditure on staff salaries and wages by about $500,000, and then employee overtime up by 40%. So I'm just wondering, are we having some difficulties with staffing here?
No, we have, you might recall when we put in new positions into the budget, we then advertise them, so they're not filled straight away. And also when staff leave, there's a period between when that position is vacant and when the new staff member arrives. By and large, we haven't had any problems recruiting staff in terms of those positions. It's just normally a time frame between when someone would leave and when a new position starts. That'd be the majority of it.
Okay, thank you. Thanks.
Can I just have a piggyback?
Fire.
Would the overtime relate to the fire?
That was my question, thank you. Wouldn't have got into there yet, would it? No. How is staff training going with regard to its budget? I notice it's not in there, it's not mentioned whether it's above or below. I'm assuming it's running
Deleted.
on target, Mr. CEO.
Well, that clearly means it's on target, Councillor Jurisic. So your standard question, so it's not there, it's good news.
And of course, capital expenditure, I mean, a significant showing below budget there, but I'm assuming that's just down to a timing of when projects are undertaken. Capital expenditure is never a linear figure, and of course, I'm assuming budget-wise we do have more of a linear target than we do with regard to when projects.
Yeah, look, that $3 million year-to-date variance is a lot of it's. There's $1 million of that's fleet. We did expect to purchase. So we're bulk purchasing out. We've got 12 utes. We're replacing. We were expecting to purchase them last month. However, there's been a bit of a timing issue.
That's just a timing issue with regard to availability of vehicles, or?
That's right. Another chunk of that is the North Shore campground redevelopment. So obviously we thought we'd get a couple more progress claims in because that's tracking quite well, that project. However, they didn't quite come in prior to the end of the month.
So the work is progressing well. It's just a matter of the timing of the invoicing coming in for payment. Thank you.
And the other probably major item there in terms of that variance with Rufus Street, there's probably a couple of $100,000 there just in terms of that tender being decided, I think last month, and now getting things moving there. So it's an ongoing cash flow phasing issue with our infrastructure services guys to make sure that the year-to-date budget reflects what we're delivering.
You've related to two fairly significant projects that are being undertaken at the moment, Rufus Street with the community house redevelopment and the North Shore campground. They're two significant projects that'll have a large part of that slice of that budget.
So the $3 million year-to-date variance, I'd expect that to be chewed up by the end of this calendar year. So.
Okay. Any other questions?
Yeah, I have another one.
Far away.
In page 12, there's a couple of things that seem to me to be community services. Parks and gardens operations and maintenance programs are $86,000 below year-to-date budget, and public amenities, materials and services, $77,000 year-to-date budget. So I'm just wondering, that seems to be things that we are committed to making sure that there are services to the community. And I'm wondering
business as usual activities, yeah.
Good questions. The Parks and Gardens year-to-date variance, a lot of that relates to mowing. As you can appreciate, we've had quite a dry spell until probably the last couple of weeks.
Yeah.
So that they're actually able to negotiate with our contractors to reduce service levels, because you don't need to mow dirt.
Until the grass starts to grow again.
So we're not going to, we look like fools, to be honest, if we're mowing dirt. So they've rescheduled with our contractors to delay or defer under our contract.
Right.
The other one, there's arborists, so they're a little bit, the arborists have a annual programs quite significant in terms of tree maintenance. That's about 20,000 below year-to-date budget. So, but again, I rely on Matt Hanson and his team to manage their spend around that. So, again, that's potentially a timing issue given the fact that in previous years they've actually come back asking for more money in their budget each year.
So there was also public amenity materials and services. So
That one's an odd one.
is that to public amenity? Again, that's very low as well.
Yeah, look, and in that, about half of that variance relates to water and sewerage charges.
Okay.
So we need to probably investigate. Our budget's based on a little bit of historical actual there, and also
That is odd.
a bit of phasing. So we just need to have a look why that's below year-to-date budget. It may be a phasing issue in terms of the invoice didn't come in or wasn't accrued. The rest of it is around contract services. So we need to understand what is it maintenance? Is it? I know they have a reactive maintenance budget within the public amenities, so that could be the fact that there's potentially less vandalism than what they're expecting this time of the year.
It could be a good message. And
Yeah.
Unity Water holding off on their water bill's not a bad message.
They never hold off on their
Councillor Parton, you had a question, or?
Oh yeah, just in relation to the interest rates, obviously we know that interest rates are virtually collapsing across the land, Reserve Bank, etc. So a question to Michael, and I'd expect he's factored this in going forward, but just a question with regards to, as we unwind our fixed rates at the good interest rate, you look into the future, Michael, with regards to our investments, with regards to that going forward.
Any return?
Yeah, we have got some
Over
locked
time.
in. QDC always gives a good return above benchmark, given the fact that they've got significant pool in the industry. They've got a lot of cash that councils put with them to invest. So we've got that bulk buying opportunity there. But look, it's still a risk. You know, we've only so much of our money is locked into term deposits that have a decent interest rate component. However, we're always looking to maximise where we can, steal an extra dollar here and there.
Insurance premiums 33k above budget. Have we had some increases in insurance premiums?
No, I think
So we
that's
thought
a
our
general,
workplace health and safety was starting to take a.
It's not workplace health and safety. It's our general liability cover, and that's a lot of that's industry based. So we budget what we think back in February. However, when the premiums come in, obviously LGM have decided that it's based on their factors and their actuary calculations. They're passing on a bit more cost to councils.
Okay, so they have increased. Premiums have increased.
There is a slight increase though in our industrial special risk component of the premium. That's effectively our building insurance, because we do have some new buildings that have come on, and since they've come on, then they've adjusted, so we're paying a bit more.
But overall, the insurance market's going up a bit.
Yeah.
Mm-hmm.
I have another one.
Please.
The budget for legal appeals, development assessment legal appeals, is 1.1 million, and in one quarter we appear to have already spent 448,000, which is 41% of that budget. How does this augur for the rest of the full financial year?
It's probably a risk, to be honest, Councillor Jackson. It's the cost of defending our planning scheme, and we need to closely monitor that in terms of potential budget impacts and the ability to fund any potential budget overrun through additional revenues or cost savings. So that's something we're going to closely monitor in the next 6 months.
The other thing that tends to happen around there is that there's like a trial season, for want of a better phrase. A lot of court appeals are heard leading up to Christmas, and the court goes into recess, so you don't tend to incur as many costs around that
December, January.
Christmas.
The next quarter, yeah.
Correct. Yeah, but we, there are, whenever we have a trial, we spend a lot of money on that.
And I have one final one, and that's on page 16, net financial liabilities ratio. And it's probably just some explanation here, because it appears that it shows a year-to-date actual at minus 41.1%, and I probably need an explanation.
So the net financial liabilities ratio is effectively your net assets, so your current assets less your liabilities divided by your revenue. So what we're seeing here is the reason that negative means good here, so it means we've got more capacity to borrow. However, part of the net assets is our cash, and our cash position at the moment is very healthy because we received our rates revenue in July, or actually August is when the cash comes in. So our cash at the moment is very healthy, which we'll be spending over the next few months as we lead into Christmas, and then our next rates runs in January. Hence why that net assets figure is higher than at this point in time in the year, but that will slowly reduce back to budget over the course of the year. It'll probably go down to possibly around that 5-10%, and it'll jump back up probably in February next year when we receive our cash for our next rate run, but then it'll come back towards budget figure again. So it's a cash timing issue.
I'd even say the budget's a minus 5.7%. I mean, that's a very healthy position to be in overall, isn't it?
Very healthy.
Oh, yeah.
And that reflects the fact that we've got $20 million, with $20 million of debt. We're in a healthy position.
Thank you.
Can I have a mover? Thank you, Councillor Jackson. Seconder? Councillor Glasgow. You should speak to it, Councillor Jackson.
I know.
Well,
Councillor-
I'll just
Councillor Pardon, you want to
just
talk to
to thank Michael and his staff. Always prudent, the guys and girls down there, and it goes without saying, and Councillor Jackson pointed to that for minus 41%. I mean, the position Noosa Council is in compared to a raft of councils, not only across Queensland, but probably across Australia, is a very, very powerful position, really, financially, and really, doesn't keep me awake at night, this part of my council hat, because being in this position, I suggest a lot of states and Australian governments have a look at this. The shocks that come, things that change, and I've just mentioned interest rates before getting lower, and so your capacity to earn, if you like, investments. Council's no different to a lot of self-funded retirees. It's just a bigger pot that's managed here with a far, of course, raft of different issues, of course, and businesses, etc., that we deal with. But we have to look at our opportunities, and we will go on forward. We've, as been alluded to, upgrading caravan parks, etc. Some of our other businesses. I see the Leisure Centre, for example, in here is up about 40,000. This is credit to the staff running that. It's a game of unders and overs at the moment. Some revenue will be up, some down. But at the end of the day, that reduction of debt has put us so strong that the council can absorb shocks here. And we don't know what shocks are coming, and I suggest the world, the International Monetary Fund doesn't know what shocks are coming. So if you've got it, it's the old adage, if you've got a quid in the bank, you can absorb those shocks, and that's where we are. If you haven't, and you cop them, you've got all sorts of trouble. So I thank staff very much. I mean, I'm always trying to spend money as a councillor, no different. On the good things, I'll add, for my community, but the prudence that the staff have shown for us, the way forward has been tremendous and sets us in real good stead.
Just a quick update too. Sorry, I was going to mention we've started a discussion with Queensland Treasury looking at that current 6%, and doing a bit of modelling over what would that look like if we actually retired that debt and reborrowed.
Yeah.
My gut says it won't work, given the fact that there's a market value adjustment. So it could be which effectively, banks don't let you do that effectively, because why would they? However, we're still going through that exercise to determine whether there is any opportunity there to retire that 6%
I
debt.
appreciate the fact you're at least looking at the opportunities there. I mean, if there's, we've shown that it's a significant saving to the council. So
Just a question through you, Mr. Chair, to Michael on that issue. Could we retire it at QTC and then go to the banks and borrow it, under the guise that...
No, under the Act we cannot.
Always looking at the smoky deals, but
that's right. You were interrupted during your discussion there. You finished, Councillor Pardon?
Yes.
Nothing further to add?
Said enough.
Anybody else? Councillor Stockwell?
It's a question. So we've looked at where we are under and over in our revenue, but how's our project about looking at alternate revenue sources going? Seems to be quite quiet.
It's going.
We've only just employed a person, haven't we?
Yeah. Well, the property side is progressing, but we'll need to bring back an update on the project. The working group's formed. We're reviewing the strategy, which we still need to bring back to council in terms of looking at the overall strategy and timeframes. But obviously, it's I'm having to juggle that project among my other responsibilities. So
I just don't mind interest in the property side of it.
Yeah, we're I'm conscious of the fact that it's hanging there ready to progress. So there's a lot of opportunity there for us.
Well, including that is the redevelopment of the North Shore campground. That's one of the projects that's certainly in there.
There's pent-up demand, Mr. Chairman.
Pent-up demand? Well, some places are closing down caravan parks and camping grounds. I think we're looking to expand ours, which is great. I'll only add, lovely to see the water bottle filling station MOU and the Unity Water contribution towards some more water stations being added. But I have got a question with regard to the spur revenue down. Is that an indication of how difficult money is, how tight money is at the moment, or and the difficulty Spur are having actually acquiring that revenue, chasing those debts, or?
Yeah, I'll need to talk to Phil Anson about that, whether it's a timing issue, because they're forecasting how much they might get out of Spur in terms of, and that's passed on obviously to, if someone doesn't pay their fine, then they get
in times of financial difficulty. I assume that there's going to be a lot of, it's going to be harder to acquire outstanding debt. So
I'd suggest it's the opposite.
Or fines?
I think if it was higher than budget, it would indicate that fines are not being paid. But because it's under budget, I think it's
the other way around. Okay, that we're actually getting
But it could be.
I hadn't thought of it that way.
Yeah, it could be a timing issue.
Okay. Yeah, okay. I hadn't thought of it that way. All right. No, nothing further from me. Do you wish to close?
I don't think I need to close.
All good. So I'll put the motion. All in favour? Carried unanimously. Thank you. Thank you, Michael. I think that's the last item on the agenda.
It is.
Thank you, councillors. Thanks, staff.